Welcome to the Enforcers panel. We have a great panel here. We are joined for the first time by the U.S. Attorney for the Northern District of California, our host, Ismail Ramsey. Before being named the U.S. Attorney, as he was a founding partner of the white-collar boutique Ramsey and Ehrlich. Earlier in his career, he was an AUSA in the Northern District of California. He has not one, not two, but 3 degrees from Harvard, including his JD, and he is a veteran of the U.S. Air Force. Thank you for your service. Skipping around next to me is Marshall Miller, the Principal Associate Deputy Attorney General. He's involved in the oversight of all department components. He was previously in private practice, first at Wachtell and then at Kaplan Hecker. During the Obama administration, Marshall was the Principal Deputy Assistant Attorney General and Chief of Staff in the Criminal Division. Earlier, he served as an AUSA in the Eastern District of New York for 12 years, ultimately as Chief of the office's Criminal Division. Next to, between Izzy and Gerbir, is Nicole Argentieri. She is the Acting Assistant Attorney General for the Criminal Division, which on the white-collar side includes the fraud section and the money laundering and asset recovery section. Nicole also previously served as the Criminal Division's Principal Deputy Assistant AG and Chief of Staff. Earlier in her career, she spent over a decade as an AUSA in the Eastern District of New York, where she held several leadership positions, including Chief of the Public Integrity Unit. During the time that she was in the EDNY, she investigated and brought charges for civil rights violations related to the sexual abuse and rape of federal female inmates by MDC prison guards. And in an unrelated case, she had a hit put out on her by a Bonanno family capo. She was previously a partner in the white-collar group at O'Melveny and Myers. Between Marshall and Gerbir is Ian McKinley, the director of the CFTC Division of Enforcement. Ian has been enforcement director of the CFTC since February 2023, and he bravely was on this panel last year, minutes after being sworn in. Ian was a AUSA in the Southern District for more than a decade, serving the Securities and Commodities Fraud Unit as co-chief of the Complex Frauds and Cybercrime Unit. And smack dab in the middle is Gerbir Grewal. He's a director of the SEC Division of Enforcement since 2021. Before that, he was the Attorney General of the great state of New Jersey. And before that, he was the District Attorney of Bergen County, New Jersey's most populous county. Gerbir also, earlier in his career, was an AUSA in both the Eastern District of New York and New Jersey. So in previous years, what we've done is we've given each panelist an opportunity to outline their favorite achievements and their priorities for the next year. And that has been a good way to kind of get an overview of what they're looking at. The problem is that that generally takes about half of the session. So we're going to try something different this year. We're going to actually discuss concrete subject matters, and through that, our panelists will get a chance to talk about their priorities and their accomplishments. I want to start by talking about recidivism. The Deputy Attorney General gave a speech here in 2021 about a new policy about corporate recidivism. And both the SEC and the CFTC have recently announced tougher approaches to repeat corporate offenders. So recidivism is an old recognized concept where it applies to individuals. And we understand why individuals are treated more harshly to establish specific deterrence when they're recidivists. It's a little bit more complicated when it comes to imaginary people like corporations. And it's tricky to decide whether a company is truly a bad apple or a recidivist as opposed to just a business which has more than one bad apple. How do you do that, and how has the Deputy Attorney General's, the policy she announced, been applied in the time since her announcement? We're going to start with Marshall, since he is in the deputy's office.
Well, thanks, Eitan. Look, I think your point is well taken that corporations are different than individuals, and yet I think we start from the proposition that some of the same principles apply to corporations as to individuals. And I think the first principle that the Deputy Attorney General laid down was that consecutive or succeeding NPAs or DPAs would be disfavored. Not that it's impossible, but that we shouldn't be in the business of doing successive NPAs and DPAs one after the other after the other. So that was a principle that she laid out. And then she laid out a second principle back a couple years ago, which is that the full criminal, civil, and regulatory record of a company that's in the crosshairs of the Department of Justice and that's discussing, for example, a potential resolution, that full history should be considered. I think rightly folks raised questions about how should it be considered and how can folks who represent companies have a sense for what to expect, what kinds of principles the department would apply. And so the department, through the Deputy Attorney General and through our Justice Manual, which all of you know well where to find, has set forth the factors that we think about when we think about how to take on the task that you mentioned of how to consider a company where multiple bad actors have engaged in misconduct, and what kinds of resolutions, prior resolutions, will be considered and how they'll be considered, because of course not all resolutions are alike. So I think one of the primary goals that the Deputy Attorney General has laid out is to be transparent in our corporate criminal enforcement efforts, and transparency, I think, is laid out through those Justice Manual provisions that set forth the factors that our prosecutors apply. I think the last principle, and this will presage, I guess, something we'll talk about a little bit more later, I think, is that the best way that a company can avoid the consequences of recidivism, the consequences of engaging in misconduct after a prior resolution, is to engage in voluntary self-disclosure. And in her speech and directive and in our policy coming thereafter on voluntary self-disclosure, that principle is made very clear that no company will be required to take a guilty plea in a resolution if they voluntarily self-disclosed, even if it's a successive resolution. And this gets at another way that we can separate, to your point, those companies where bad conduct just happened to happen, as opposed to companies where there's a problem. They're either not getting the message, or they're not establishing the kind of compliance programs that we expect to deter conduct and to identify it where it happens and self-report it.
Gurbir, how is the SEC treating recidivism differently now, corporate recidivism?
Sure. Before I answer, as is customary, my remarks this afternoon are in my official capacity as enforcement director and don't necessarily reflect the views of the commission, the commissioners, or the staff, and I'll do that for you as well, and whoever else needs coverage. I've forgotten to give it, and nothing bad has ever happened. So, listen, we're uniquely focused on recidivism, and I think there's three things that I would want to share with this audience. One, what is it we're talking about when we're talking about recidivism? Two, why is it important to us? And three, how we're addressing it. We fully understand on the first point that large registrants, large banks, are going to have more violations just because of the sheer size of the organization. They're going to have technical violations. They're going to have, all manner of compliance issues just given how big they are. And so it's not that we're not looking purely at those technical violations. We're looking at the nature of all the violations. So, if there are scienter-based fraud violations, if there are more substantive violations, we're going to take all that into account. And why is that important? It's important because I think the AG touched on it very well. There's been a decline in trust, both in regulators and in financial institutions. He talked about how there's this perception out there that there may be two sets of rules out there, one perhaps for the big and powerful and another for everybody else. And to regain that trust, to address those issues and to give the public confidence in our financial institutions and our markets, we have to be there holding recidivist actors accountable, and it can't be seen that they commit a violation, pay a penalty as a price of doing business, and move on. And so how are we addressing it? We're certainly addressing it in the penalties we seek. For a recidivist, where we have seen a series of violations over time, we're going to seek a more robust and higher penalty for the next violation. I think that's been borne out in the results over the last number of fiscal years. In 2022, we had $6.4 billion in total money ordered, which was a record in the Commission's history. Last year, it was $5 billion, which was also a record. That's not to say we're going to continue to set records, but part of the effort was to be really conscious about making sure that we're recommending penalties to the Commission that are going to have a deterrent effect on the people in our space. And I think that's what you've seen over the last number of years. That's what you'll continue to see moving forward from us. But the other way in which we're addressing it is in other remedies that we seek. We're seeking officer and director bars. It's been mentioned before, corporations act through individuals. 2/3 of our resolutions involve individual accountability as well. And so when there are individuals who are involved and their officers and directors are likely to serve as officers and directors in the future, we are seeking those types of remedies to make sure that they stay out of our market, stay out of those roles moving forward. That's an important part of addressing recidivism. Another way in which we're doing it is by including undertakings in our resolutions, undertakings that include compliance consultants to make sure that there are people in those companies making sure that the policies and procedures are where they should be. An example of this is a resolution we had last fiscal year with the accounting firm Markham. They were a huge player in the SPAC space, but their quality standards fell short. And one of the restrictions we put in place, in addition to the compliance consultant, was a restriction on new business. That's an example of an undertaking where we're saying, hey, what you've been doing to date has resulted in a series of violations. We don't think you should be taking on new business until you correct those sort of issues. And because of that, this restriction is going to be part of any resolution. So I think that's another way in which we're promoting accountability, promoting trust, making sure we're addressing recidivism. And then finally, I would say admissions. We've placed a greater emphasis on seeking admissions in our resolutions, and we've sought more and obtained more over the last number of fiscal years. And I think that sends a powerful message of accountability. That goes a long way in restoring trust and confidence in our markets and making sure that we're holding bad actors accountable and deterring misconduct in the future. So those are some of the ways in which we're addressing recidivism at the Commission.
Thanks. Ian, is the CFTC doing anything different to address corporate recidivism?
Yes, and I'll opt into Gubir's disclaimer about my remarks. But we are, and we put out...
Be known from now on as Gubir's disclaimer.
Gubir's disclaimer.
We are, and we put out guidance in September related to recidivism, and I'll give a kind of an overview of our thinking of what went into that and some of the guidance and why we put it together. When I got to the job as director, I noticed fairly quickly that we started seeing a lot of the same entities, often with the same kind of problems. So for instance, swap data reporting cases to us after Dodd-Frank. We were given regulatory authority over large portions of the swaps market, and firms were not reporting their basic data to us over and over again for years. So there were problems that I was seeing with the same entities, and that makes you question kind of the fundamental point in us doing our actions, right? I mean, obviously that keeps us in business. That there are the same matters coming in, but I was thinking, how do we solve for it? And in thinking about that, the first where I went first, Eitan, was to kind of how you started this. Like, how do you think about a corporate entity as a recidivist, and are there factors that we can and should keep in mind? And so what we did was think about a few of those factors, non-exhaustive factors that we put out in guidance, the purpose of which was to really start having that conversation, because once we have some kind of common understanding of what recidivism is, we can turn to how to account for it and how to adjust our penalties and other measures, which I'll get to in a second.
But I was also animated by Dag Monaco's speech about recidivism, because she mentioned that in the regulated space, and Gubir touched on this a little bit, the regulated space being SEC and CFTC up here, entities will have more touch points with us, and that is just a matter of fact, because they're registered with us. There's often all kinds of engagement about problems. Some problems are minor, some aren't. But it really, I think, takes some thinking to pull apart what recidivism is. And so the factors we set forward were, the nature of the conduct, and obviously no two cases are the same, but whether it's the same root cause that led to the problem. Some of the other factors are kind of similar to what you would think of in the sentencing guidelines, which I'm familiar with coming from DOJ, but applied, we think, on a more macro level, right? So was overlapping management involved? Trying to understand if the firm is the same as it was when there was a previous violation. The time between offenses, right? If something happens right away after a previous violation, that's a factor. It's not dispositive, but it's a factor like many others. And then also the remediation that a firm has taken, right? I mean, if a firm has changed their culture, they've changed their policies, when appropriate, if they've changed personnel, that's a fair argument to come to the CFTC and say, look, we're not the same person that you saw before, so you should not think of us through the prism of recidivism. So those were the factors that we put out there. And Gubir mentioned kind of how the thinking on penalties when there is recidivism, and I won't reiterate what he said, because some of the tools are similar to what we've been doing. But I think where we do find recidivism, we are going to seek or recommend to the Commission enhanced penalties. And this past year, end of our fiscal year, we had I think some of our highest penalties ever imposed, about $4 billion. And part of the policy that we put out on recidivism includes our first policies on monitors and consultants, and some general things to think about that. And I think, as is relevant to recidivism, where we see that and where we see large-scale compliance failures, we'll be inclined to recommend a monitor, a third party approved by the division to help a firm with their compliance.
Ian mentioned the sentencing guidelines, and sentencing guidelines are dependent on the two axes of the grid, right? One of them is offense level, the other one is criminal history category. For an individual recidivist, their criminal history category is going to go up and their guidelines range will go up. Nicole, is there any analogy to that for corporate sentencing?
Sure. So if it'd be helpful, I'm going to dig in a little bit and get more granular and a little bit about what Marshall was talking about. So when we're ready to resolve with a criminal corporate defendant, we sit down and we look at the guidelines just like we do with an individual, and we figure out, based on the nature of the conduct, where in the guidelines range the penalty will be. And then we ask two questions. First, has the defendant qualified for a reduction based on their cooperation and remediation? And second, if they do qualify for such a reduction, where within the guidelines range are we going to take that reduction? So on the first question, I think we spend a lot of time as a group talking about what it means to get cooperation and remediation credit. Under our revised corporate enforcement policy, I'm sure everyone in this room knows, every company starts at zero. And to be eligible at all, a company has to provide all relevant non-privileged facts about the individuals involved in the misconduct. It's very fact-specific. We try to put a lot of details into our relevant considerations that get issued with every resolution as a roadmap to the types of things that we value when we're looking at cooperation and remediation. But let's assume for this hypothetical that a company has qualified for that reduction. From where do you take it in the guidelines based on their recidivism? And under the DAG's memos from 2021 and 2022, there are some markers that Marshall described that we look at to determine how are we going to value prior misconduct. First of all, is it a criminal resolution? How recent is it? Is it more dated, for example, civil conduct? And And then we basically try to figure out where to go from there in terms of where we're going to start in the percentile. And I think it would be really helpful to think of it in terms of a recent resolution we entered into this January with SAP, which is a global publicly traded software company. It's in every country in the world. They bribed officials in 2 countries to retain and obtain business. So SAP didn't voluntarily self-disclose, right? So the most cooperation credit, remediation credit they could have gotten would have been 50%. They were pretty extraordinary. They were very responsive as soon as the news of their misconduct hit the press. And so we decided that it would be appropriate to award them 40%. But then, looking at their prior resolutions with the government, they had a 2021 NPA with the National Security Division. It related to conduct that they had, in fact, disclosed while they were cooperating with our investigation. And if you look at the type of misconduct, it wasn't sort of an organized scheme. It was a lack of control issue. They also had an earlier resolution, I think it was a 2014 resolution with the SEC related to FCPA violations, no admit, no deny, limited to 1 country. We took a step back. How did we evaluate that? Well, first of all, the type of the company. Because of the size of SAP, because of the breadth of its business, because it is in every single country in the world, because they're interacting with government officials in many countries, and because of their cooperation, we ended up taking the 40% from the 10th percentile in the guidelines range, taking into account all of the factors about the NSC resolution and the prior FCPA resolution. A good contrast to that is the DPA we entered into with ABB in 2022, again involved bribery conduct in South Africa. Again, very, very extraordinary cooperation. At the time, under the old CEP, ABB received the max you could get if you hadn't voluntarily self-disclosed, which was 25%. ABB, though, was a 2-time prior FCPA offender, criminal resolutions, I think both within 10 years. But because of their cooperation and remediation with the company, they ended up not having to plead guilty, which I think is a good lesson for companies who are recidivists, who are faced with additional misconduct. And they were able to enter into a DPA, but they received their reduction from the 75th percentile in the guidelines range because there were 2 prior criminal resolutions.
Thanks. Izzy, you're new on the panel. We haven't heard a lot from the Northern District of California in this forum in recent years. I know that you recently did some reorganizing of the office and have a renewed focus on white-collar crime. I also know that the Northern District of California includes Silicon Valley. Can you talk about how that affects your priorities and talk about your office reorg?
Yeah, absolutely. First of all, thank you for having me on the panel, and just want to welcome everyone to the Northern District of California and to our great area. No doubt, the most defining aspect of our district is that Silicon Valley is here, and it's the innovation and technology capital of the world, and also is now the AI capital of the world. Part of San Francisco now often being referred to as Cerebral Valley. So we have reorganized our office in a way that will allow us to focus on these priorities, and particularly national security in terms of securing and protecting our nation's intellectual property and its most sensitive secrets. So in that sense, we previously had a corporate and securities fraud unit, and then we had a special prosecutions unit that did all sorts of white-collar cases outside of securities fraud and straight corporate. We now have created a new unit, a national security and cyber unit, which is in line with some of the changes that have gone on in the National Security Division. So we now have 3 units. We have the corporate and securities fraud, which does the traditional securities fraud work. We then also have the special pros unit, which does things related to public trust, so civil rights, environmental, tax, public corruption. But now having the National Security and Cyber Unit allows us to bring a greater intensity to protecting the intellectual property and the innovation that's being developed in Silicon Valley and also in Cerebral Valley. I think that's indicative today, the Attorney General announcing a trade secrets case that was unsealed today relating to the theft of trade secret related to artificial intelligence from Google. I do want to at least thank a couple of our team members who spearheaded that effort. Laura Vartan, who's the chief of our new national security and cyber unit, and Casey Boom, who's here, who is the lead prosecutor on that case. So that's our new structure. That allows us to focus also in line with the DOJ and Department of Commerce's Disruptive Technology Strike Force. That's obviously collaboration from various units to try to make sure we protect these. We're continuing to do the same sorts of work that we've done in Silicon Valley in the past in terms of crypto enforcement related to securities work, traditional things like insider trading, through our corporate and securities fraud unit, but this new structure allows us to bring a greater intensity to this work.
Thanks. So speaking of crypto, it seems to be a target-rich environment for both criminal prosecutors and civil regulators. Ian, you were talking about the annual results of the CFTC for last year. One thing I noticed in looking them over was that fully half of the matters that the CFTC brought involves crypto or other kinds of digital assets. That's up from, I think, like 20% the year before. And I know the CFTC has been in the crypto space for as long as crypto's been around, but there really does seem to be increasing amount of resources and bandwidth devoted to crypto. Is that accurate?
Yeah, that's accurate. And I'm going to steal one of your lines from a previous panel about why it's such a big focus.
It's a good line.
All credit to you. But yeah. Willie Sutton, the famous bank robber, was asked, "Why do you rob banks?" And his famous answer was, "Because that's where the money is." And so I think when you and I'll give some other reasons about our docket and focus on crypto, but obviously there's just a tremendous amount of fraud and manipulation in the space still, and I say that through the actions that we've brought and that others on the stage have brought. I think, Eitan, just to put a fine point on the statistics that you mentioned, because it's really incredible. We brought the CFTC brought its first crypto case in 2014. And now we're a decade later, and half of our docket, basically 49% of our docket last year, was crypto-related cases. And so it's a tremendous focus for us, and I think part of the reason why we're so active in the space is I think we are really good at it, and we've brought some really impactful matters over the years. We just had a huge settlement in parallel with DOJ and others against Binance for offering offshore derivatives and failing to have a adequate anti-money laundering program. That was a $2.8 billion settlement for the CFTC. We previously had a settlement with BitMEX in 2020, I believe, for $100 million. A settlement with Tether a few years ago for misrepresenting that its stablecoin was backed by U.S. dollars. So just an incredible track record over time, and that's really testament to the hardworking women and men at the CFTC and some of the expertise and structures that we have. So we are, a lot of people don't really know too much about the details of how the CFTC is organized. When I got the job, my mom actually didn't know what it was, so I had to break it down for her. But we have offices in New York, Washington D.C., Chicago, and Kansas City, and we work some cases across offices, but oftentimes it is an office-driven kind of docket. But for some particular areas, we have task forces, which are composed of folks from all the offices, and that includes attorneys. We have investigators, similar to the agents that the DOJ folks have, and support staff, obviously. And so we've had a digital asset task force for almost as long as we've been bringing cases. And it's really a group of folks who are steeped in the subject matter. They can do the tracing analysis. And so it's really a testament to them that we've been so active in the space. I think in terms of the cases that we're bringing, Eitan, they run the gamut. I would say that one of the high-level takeaways are that crypto cases are starting to look a lot like regular white-collar cases, kind of across the board. And so, we bring fraud cases. We have it's ongoing. The FTX matter that we brought in parallel with DOJ and SEC. I think this is an ongoing case, but I think it's a very interesting case. It's the Eisenberg Mango Markets case, and there the allegation is that the defendant was trying to manipulate a certain benchmark to benefit his positions in digital assets. And when you think about that, when I think about bread and butter type cases that the CFTC has brought over the years, it's often manipulation of a benchmark or some other kind of reference mark to benefit a position in another market. And so we're now seeing that in the digital asset space. And then I mentioned with Binance and BitMEX, there were registration violations. So offering CFTC products, but as digital assets, but failing to comply with our regulatory regime. So failing to register as a futures commission merchant, as a swaps execution facility. And these are important cases. I think it's been said before, but it's really worth stressing that registration is not just paperwork. There's a lot that goes into it when a firm registers, and there's solid requirements that have been thought about for a very long time about keeping customer assets separate, about policies and procedures, about margin requirements. So we find that registration cases are very important.
Gurbir, what about the SEC? Are you guys also devoting increasing proportion of your resources to crypto? And how's it going in the effort to define what digital assets are or are not securities under Howey?
Crypto takes up a lot of the conversation, and understandably so, but I think it's important for us to just put it in perspective that the entire global crypto market cap is $2 trillion. The total market cap of all NYSE and NASDAQ listed companies is about $50 trillion. Registered investment advisors with the commission advise funds with assets of nearly $20 trillion. So you have $2 trillion, $50 trillion, $20 trillion. So we are focused on crypto, but we are also focused on those other spaces. We are focused in the private fund space, a really opaque space where we see a lot of potential for harm to investors as more and more retail investors get exposed to private funds. And we've done great work with the Southern District of New York in that space, holding bad actors accountable for mismarking, for valuation issues, for fraud. And I think those are important cases that sometimes get lost when we start focusing just on crypto. And to build off what Izzy was saying, we're here in Silicon Valley. We're here, and the SEC has a presence here as well. We have regional offices that focus on the harm to investors in their regions. And here, our office, along with Izzy's office, is focused on the harm to investors from startups, from founders who are engaging in offering frauds. We did the Theranos investigation with Izzy's office, and I think that trial, or the last of the trials, recently concluded. That was $700 million raised from a huge number of investors. With the Southern District of New York, we have a parallel action with StimWave. They're on trial, I believe, in that case right now. But yet another startup case where, based on promises of medical technologies, about $40 million was raised, we allege, fraudulently. There are other cases in that same vein that are unique to this part of the country that we're focusing on. So again, I don't want all the other work to get lost when we talk about crypto. yes, crypto is incredibly important to us. Yes, it is where a lot of the money is. And yes, we have been working incrementally, moving on from the ICO registration cases that we brought years ago to move on to where we see the risk now with the intermediaries and the platforms and the exchanges, where entities like Binance, entities like Coinbase, entities like Kraken are combining all these functions under one roof. And we allege that there's a lot of risk there. We allege that they are not registered and providing the type of disclosures that the investing public should be getting. We allege that that type of combination of functions under one roof leads to more conflicts of interest. So we are in litigation with all three entities, and it's active litigation. I'm sure many of your firms are against us on the other side of that litigation because it is existential to those firms, but it's as existential to us because if investors are not getting those disclosures, they're at risk. And we saw that risk on full display in the collapse of FTX. And so we'll continue to focus on the intermediary cases, on the unregistered dealer cases. And that will be something that we'll continue to focus on until people come into compliance in this space. And there's a lot of non-compliance. The other areas where we're focused on here is the touting cases. I think one thing that gets lost in the crypto space is how vulnerable communities are being targeted by celebrities who have been hired by crypto issuers and by others in this space with promises of generational wealth and almost predatory tactics that harken back to a prior day in other businesses. And a lot of the people who are bearing the brunt in this space are Black and brown communities. And I think that's getting lost when we talk about all these other issues about, registration violations, and we talk about these other, whether something's a security or a commodity. The investor harm that's going on right now is something that we're keenly focused on. So, whether it's our action against Kim Kardashian or Paul Pierce or others, those are incredibly important cases to us. And they're important because people are targeting vulnerable communities with these promises of generational wealth, which are not being delivered. The other thing we're seeing, building on what Ian said, is traditional frauds now with a crypto wrapper. These multi-level marketing schemes, these pyramid schemes, now under the guise of crypto. We just brought a case with the District of Maryland in parallel with them, with an entity called Hyperfund. They raised $1.7 billion from investors. And we allege, and the criminal authorities allege, that it was nothing more than a pyramid scheme, a traditional pyramid scheme under the guise of crypto. And again, thousands and thousands of investors being harmed. So it's incredibly important work that we'll continue to focus on. We have a team dedicated in our Philadelphia office working on these MLM pyramid type schemes with these crypto wrappers to make sure not just that we're bringing the actions, but also that we're following up with investor education to give people the information that they need to ask the questions that they should be asking before they're making these investments. Because again, those registration requirements are important because of the disclosure that comes with them, and that disclosure is not currently available to a whole swath of the investing public. So it remains an area of focus, but part of a broader focus on investor protection.
Nicole, there's been a task force at the department on crypto for a couple of years now, the National Crypto Enforcement Team. Can you give us an update on what their role is?
Sure. So the Deputy Attorney General directed the Criminal Division to stand up the National Cryptocurrency Enforcement Team in 2021, which is a team dedicated to prosecuting complex crimes involving cryptocurrency and criminal misuse of cryptocurrency. And just since we last saw each other in July, we formalized that the NSET would sit in the Computer Crimes and Intellectual Property section, but it remains really like a super team of experts in crypto. And what do I mean by that? The NSET is made up of prosecutors from the Money Laundering and Asset Recovery section who have great expertise in prosecuting and investigating financial institutions, including around crypto, which I'll talk about in a second. It's also made up of members from the Computer Crimes and Intellectual Property section and from the fraud section, and with a cross-section of detailees from US attorneys across the country, which is just an exceptional way to build capacity to do these cases and develop best practices across the department. And we have just had great results this year. I couldn't be more proud. This December, the founder of the cryptocurrency exchange Bitslato, Anatoly Legetimov, that's a tongue twister, say it 3 times, pled guilty in the Eastern District of New York to operating an unlicensed money transmitting business. And it's remarkable when you think about it, over $700 million. Their greatest counterparty in transactions was Hydra, which is a darknet market that Izzy knows all about. And over $12 million in ransomware proceeds flowed through this cryptocurrency exchange that basically required no KYC. They were proud of it. And so when Legitimov pled guilty in December, not only did he plead guilty, but he agreed to wind up that exchange, and he forfeited over $20 million in the assets that were seized that were related to the business. Just a tremendous result. And that really follows upon the guilty pleas that we announced late last year by Binance and its CEO, Changpeng Zhao. That was the result of a years-long investigation by our money laundering and asset recovery section and our deputy NSET director, Kevin Mosley, among others, and really just showed what they were trying to do was build a business and prioritize profit and growth, taking advantage of US users, US market makers that they needed for liquidity, while following none of the rules that we have in place to protect our markets and investors. And those guilty pleas were significant not only because it was one of the largest financial penalties imposed against a financial institution or the first corporate resolution with a cryptocurrency exchange, but because the CEO agreed not only to plead guilty, but to step aside from the business. And that is a business now that will be very shortly under monitorship. So I think we're doing great things in this space to incentivize these businesses, these cryptocurrency exchanges, also mixers and tumblers, right? That try to obfuscate criminal proceeds flowing through them and make this market more compliant. And I think in addition to the tools of prosecution, very often we use a different tool, which is disruption. And in November of last year, NSET, along with our Dutch and Finnish partners, engaged in a disruption operation to take down the infrastructure of Sinbad.io, which is a mixing service that basically processed millions of dollars worth of transactions from the Lazarus Group heist, which is basically a key money laundering tool of North Korea. So I think what you can expect from the criminal division and from this group of really dedicated professionals is to keep pushing in this space to make sure that we are sending the message that if you want to be in this business, you want to access US markets, you have to follow the rules.
I just add one quick thing. I just want to point out, as the Attorney General talked about earlier, in this space, in order to be successful, you have to have the expertise and the personnel, and you have to invest in that expertise and personnel to reap the rewards that Nicole was talking about in terms of some of our NSET successes. And I just want to highlight that we also, when the DAG directed the stand-up of NSET, the National Crypto Enforcement Team, we also worked with the FBI to stand up their virtual asset units and invested in the expertise at the FBI so that we can track the blockchain, we can match the crypto firms in terms of our expertise of how crypto works. And without that kind of investment, and we're seeing the same thing now in the AI space, without the investment in that expertise, you won't have the ability to bring these cases. And I think what you've seen and heard from our regulatory partners and from Nicole is that investment that we've made also in the U.S. attorney community, and I'm sure Izzy will reference this as well, through the coordinator network that we have in the digital asset space there. We've really invested, and now you're seeing the product of that.
Let's talk about voluntary self-disclosure, which is the favorite topic of all of the panelists. The DAG is very big on this. It's really a perennial topic. I mean, you guys come to this conference and you tell the assembled defense attorneys about, just how awesome voluntary self-disclosure is and all the, great rewards that await our clients if they do voluntary disclosure. And sometimes that's coupled with, the stick, the threat. I mean, there was a panelist this morning from the Southern District of New York who quoted one of Damien's mottos, which is, call us before we call you. So there's a carrot and there's a stick, but it is a hard decision for defense attorneys deciding whether or not to cross that Rubicon. That is not a line that can be uncrossed. And it's not because, defense attorneys or companies want to be free to continue to, gleefully commit more crimes, right? There's other options. You can you can do remediation, you can fire the bad guys, and then you can, take your chance on whether or not the government's going to come calling. What should this audience know about why voluntary self-disclosure is the right call? Because it is, I don't think that there's necessarily an appreciation for how difficult that decision is. Let's start with you, Marshall.
Sure. Well, thank you for that. And I do think while there has been talk about voluntary self-disclosure for quite some time, I think there's been a shift from the government's perspective in the way that we think about and that we're messaging this and that we're moving out on it. And by that I mean when the DAG rolled out our approach to voluntary self-disclosure, she really wanted to focus on three things. She wanted to focus on transparency, consistency, and predictability. So transparency, until the DAG directed it, there weren't clear and transparent policies across our prosecuting components about what voluntary self-disclosure meant and what the benefits were that you could receive if you voluntarily self-disclosed. Didn't exist. Now, every prosecuting component has a voluntary self-disclosure policy, and we have a single policy that governs the entire U.S. attorney community, all 94 U.S. attorneys. So with the click of a mouse, you can figure out exactly what the policy is, what the requirements are, and what the benefits are. So that's transparency and consistency. From a predictability standpoint, the DAG also set some basic threshold sort of floor for what every single Department of Justice VSD policy will get you. Now, some components have taken it to another level and have offered additional benefits. We can talk about those. I'm sure Nicole can talk a little bit about the criminal division and the voluntary self-disclosure benefit of a presumption of declination if you do you meet all the elements of the program, including the self-disclosure. But there are some baseline benefits. And all of this is geared towards assisting with that decision-making. It's geared towards assisting with general counsels and outside counsel who go to a board and say, what happens if we self-disclose? How do we make that decision? What can we stand to gain? What are the risks? And so the more, I think, transparent, consistent, and predictable the policies are, the more that folks start to use them and start to see the benefits, and some of that takes time. These cases don't happen overnight, but early returns are that there's significant numbers of self-disclosures that are in the pipeline. I think as those roll out, the clarity and predictability of the policies will then be followed by outcomes that people can look at and point to. And that's, I think, when you move the needle and change the dynamic. The second thing is, I think when you are in this space and when you're moving out and when you're taking real action, you start to see innovation. And we're starting to see that already in the voluntary self-disclosure policies that we're seeing from the U.S. attorney community bubbling up in connection with individuals. Southern District of New York announced a policy. Izzy can talk a little bit about what his office is doing in that space, but this is really voluntary self-disclosure for individuals and setting forth in clear and predictable ways what happens when an individual who has exposure comes forward and voluntarily self-discloses. And then the next wave and where we're moving to next is in what I would think of as more traditional whistleblowing. So this is where people who weren't involved in the misconduct blow the whistle on those who were. So the DAG last year announced a policy in the M&A space where a company that acquires another company and discovers in the due diligence process that there was misconduct at that acquired company can disclose. They weren't involved in that misconduct. They uncovered it. They can disclose it, and the DAG has set forth very clear benefits that occur in that position, in that situation. And I think what you're going to
benefits? I mean, not financial benefits.
No.
There's no reward.
There's no reward for the company that discloses, but what the company does know is that they will not be prosecuted. There's a presumption of declination for the company that comes forward and says, here's what we've found. They won't have the carryover liability that otherwise would attach if they acquire a company where there's misconduct. But then the next step is in the monetary space, and I think you'll hear more about that from the Deputy Attorney General tomorrow. But here the idea is to incentivize folks, as our friends from the SEC and the CFTC have done, to come forward and blow the whistle when they weren't involved in misconduct. Again, stay tuned for tomorrow. But the point here is, as more and more avenues exist for folks to come forward and either blow the whistle or self-disclose, it becomes less and less or it becomes a more and more risky proposition to sit on your hands. And we want to make the benefits clear, we want to make them predictable, and I think the consequences speak for themselves.
We will tell the DAG that you did a great job teasing but not spoiling.
I'm all about the hype.
Okay, yeah.
Right, man.
Izzy, you want to talk about the U.S. Attorney's Office's self-disclosure policy and how that's working out?
Yes. The U.S. Attorney's community has worked hard to make sure that there is transparency and consistency in this area. Serving on the White Collar Crime Subcommittee and the Cyber Subcommittee of the AGAC, we've had a rollout of our VSD policy over the last 12 months, and I do just want to note Martina Estrada from Central District of California, Eric Barron from Maryland, and Jonathan Ross from Northern District of Arizona are here, and they serve on those committees as well. And we have worked hard to make sure that there's a consistent policy that applies across all U.S. attorneys' offices, and it's been rolled out, as Marshall said, and has been approved in Main Justice so that we all have the same policy. We need to show that it's going to be applied consistently, these potential benefits. And we're doing that by making it known publicly what the results of these voluntary self-disclosures are. In our district, we've had the first public application of it in the Life Corps and Land Act area, which was an FCPA case, which actually came through the criminal division because of the requirements there in terms of jurisdiction. But what was made very clear in that declination by the criminal division in the statement there was that even applying the U.S. Attorney's Office's self-disclosure policy, we would have came to the same result. So making it clear that there is not forum shopping, that sort of across all districts we're going to apply these consistently. And I think you'll continue to see that as more and more results from these disclosures are made public through the website. I think the flip side of this also, like Marshall pointed out, is the second phase of this, which are whistleblower policies. So I think SDNY led the way with its pilot whistleblower policy. Our district now, and I'm just announcing now that our district will be rolling out a self-disclosure, a whistleblower policy that is quite similar to SDNY's next week, but it also focuses more on intellectual property in those sorts of cases. But that's the flip side of that. There will be great benefits, presumed non-prosecution when certain factors are met for whistleblowers, and these are necessary efforts, I think, in sort of building these kind of cases.
Gurbir, in terms of voluntary self-disclosure and the SEC context, I mean, on one hand, I guess you guys have, in some ways, a strong, well, not stronger because you can't put people in jail, but you have a stick because you have this whistleblower program that incentivizes people to blow whistle on their employers. But do you also have the same kinds of transparent carrots that the department has?
Listen, I understand that conversation you have with your client is a tough one as to why you should go and self-report. And we get a lot of criticism for not having something along the lines of what Justice has done and what the U.S. Attorney's offices do. We have structural barriers. We have a 5-member commission that votes on every enforcement recommendation that prevents us from having that type of program. Having said that, we do have carrots. But before I talk about those carrots, I just want to highlight the whistleblower program, because to your earlier question about, should we just sort of wait and see what happens and not self-report? Since its founding, there have been about 400 whistleblowers who've been paid a total of $2 billion as a result of that program. It is an incredibly effective program, and that $2 billion in payments to those whistleblowers has triggered off the amount of recoveries that they have brought in, percentages of those recoveries. So you are really gambling when deciding whether or not to self-report, because that program works and it results in meaningful and probably some of our most successful enforcement actions when it comes to addressing wide-scale harm in a particular space or bringing to account folks for engaging in all manner of violations, to include the FCPA violations that we work in parallel with our partners at DOJ. On the carrots, we have something called a 21A report that was issued by the Commission over 20 years ago called Seaboard. And it lays out the 4 factors that we look at when we assess cooperation and the credit you get for cooperation. Those 4 factors include whether there was self-policing, whether there was self-reporting, whether there was remediation, and whether there was cooperation with our investigation. And those are really broad terms. And I think one thing that we have done better over the last 2+ years is to put in those orders where there has been good cooperation, what that cooperation entailed, to give Seaboard more teeth. And I think you've seen that over the last number of years in orders issued by the Commission where there have been 0 penalties or reduced penalties. And some of the behaviors that result in cooperation credit, I think, were on full display in a recent resolution with a China-based issuer named Klupin. It was a revenue recognition matter where they were pulling forward revenues. Klupin identified it on their own. They began an internal investigation, self-reported not after the internal investigation was opened, but during the course of the internal investigation, self-reported, provided us with witnesses, made available translations of Chinese language documents, provided translations of witness statements, remediated, fired the problem employees, put in place new procedures and controls to address the shortcomings in their prior controls and procedures, and really went above and beyond. And so that resulted in a 0 penalty order from the Commission. And I think that's a roadmap that you could sit down with your clients and show them, like, if we do these things, here's the benefit. There's 12 others like that over the last 2 years where there have been 0 penalties. The other thing that we've been trying to implement more are springing penalties. So there's a benefit to come in. If you're on the path to remediation, if you're a new issuer, or if you are struggling financially but on the way to address these problems at your firm, we've had resolutions where we'll say, okay, the penalty is $1 million now, but another $5 million if the problem is not fixed. Use that time, work with the compliance monitor that we put in place, the consultant we put in place to address the issues and periodically report to us. But if the problem is not addressed, if the monitor doesn't assess that you're on the right track, then that other penalty will kick in. So that's another way in which we're trying to incentivize self-reporting and people to come in. But you're right, it's not as clear-cut, it's not as well demarcated as what the Department of Justice is doing, but I think it's a step in the right direction where, you know, with the threat of the whistleblower blowing the whistle on what's going on and real concrete evidence and pathways to see what the benefits are, I think you could have a meaningful conversation with your clients as you're deciding whether or not to self-report.
Ian, what's the CFTC doing to try to incentivize voluntary self-disclosure?
Yeah, so similar to the SEC's kind of overview of how it works. So we don't have a sentencing guidelines either. Although just to pause on that for a second, I don't know, when I was a defense lawyer, I never met another defense lawyer that said, I love the sentencing guidelines. They were the typical argument is that that they shouldn't apply, but the way that we recognize self-reporting is in our orders, and we try and we have guidance on the general kind of credit that we will give, and the spectrum of self-reporting is a form of cooperation. They're distinct, but if a firm has self-reported and cooperated, we're going to note that in the order, and hopefully you'll be able to see how that firm benefited vis-a-vis other firms that did not self-report. I think it is, Eitan, I think you put your finger on it. It is a perennial problem, and it is hard with clients having come from the private sector, right? I mean, the questions are, what's the risk of exposure? Where do I self-report to, given that your results in your mind may differ depending on where you go. How long is the investigation going to take? I mean, those are really tough questions. I think what everyone up on the stage is saying is trying to find ways to change the calculus, because the bottom line is we're not getting enough self-reports, right? And it's a very good thing for the system for everyone to have them. And so, some of the other ways we do it is through our guidance, that we put out. We have a civil monetary guidance policy that you can see where we talk about the importance of self-reporting. I think that we're always looking for opportunities to let that be known to the defense bar, and ways to articulate the exact number, although it's never a science, right? And so that can be challenging. I will echo what Gubir said about whistleblower programs, because I had not worked really much in whistleblower work until I got here, except for a case or two, and it's really an extraordinary program that we have. Our program was authorized at the same time as the SEC with Dodd-Frank, and we've given out a tremendous amount of awards. And I think just a few interesting stats. So 40% of our cases basically involve whistleblowers. So where that dovetails, as Gubir mentioned, to self-reporting is there are folks that are coming forward, and they're coming forward quickly. And I will say the reports, just in general, they are really substantive and sophisticated. I think there was a notion that a person at a whistleblower was a disgruntled kind of low-level employee. I'm sure that wasn't true, but that was kind of the stereotype. The whistleblowers we're seeing now are high level at big companies, sometimes in the executive positions. We've given out $350 million in whistleblower awards, and last year $16 million in awards. So the incentive is really there, and it's something for firms to keep in mind when they encounter a problem, because you'll want to get to us to get that credit. You'll want to get to us before the whistleblower.
Nicole, you get the last word on voluntary self-disclosure.
I think that's appropriate, because the concept of, just in general, but also, the concept of voluntary self-disclosure is not really a new one for the criminal division. It's something that was first contemplated in our pilot program, the FCP pilot program in 2016, that was extended to the rest of the division in 2017. And what it does, though, is it creates this presumption of a declination where a company voluntarily self-discloses within a reasonably prompt time of becoming aware of misconduct, where they fully cooperate and remediate, including paying disgorgement. And over the past few years, I think the number of declinations that we've announced really shows that policy is working. So we've had 5 declinations in the last 2 years. In one, which I'll describe, involving Corsicol, Corsicol discovered that they were paying bribes to Egyptian government officials to obtain lucrative contracts. They voluntarily disclosed that information, they cooperated and remediated. But the point is that all of these companies are committing crimes through individuals, right? The individuals are the ones committing the crime. And when companies voluntarily self-disclose, they give us the ability to get ahead of the game, to preserve evidence, to grab phones. And in that case, as a result of the company's voluntary self-disclosure, we were able to charge 2 executives. Another example is the HealthSun case, a case that we're very proud of. It's the first CEP declination we've had involving healthcare fraud. The company, after an acquisition, discovered misconduct related to overbilling of Medicaid. They voluntarily disclosed it, they cooperated, they remediated, and as a result of their self-disclosure, we were able to charge and hold accountable an executive. And what I would say is waiting on the other side is that we're not just waiting for the voluntary self-disclosures to come in, right? First of all, if you're in an industry where a whole group of companies are committing the same type of crime, you're at a risk that one of them is going to voluntarily self-disclose. So that happened with JLT, which is a UK reinsurance company. They discovered misconduct at their company. They just self-disclosed it. They cooperated. They remediated. They received a declination. Because of that self-disclosure, we opened up 2 new investigations into 2 other companies in the same industry that were engaged in the same conduct, and they did not receive declinations. And it allowed us to charge upwards of 5 people that were involved in those schemes. So what I would say is when you're thinking about it and you're talking to your clients, you don't know who else is out there, and we're not waiting for you to come to us. We are being, I think, very creative with the resources we have to try to originate and develop cases on our own, including using data, strengthening our relationship with international partners. Our agents are doing the same thing. And so I would say, do not wait for us to come to you. And if you don't initially voluntarily self-disclose, cooperating and remediating and being as helpful as possible is better late than never.
Okay. So I think the message from the panelists is that voluntary self-disclosure still remains a really, really awesome option. Let's pivot. And this is a topic just for the civil regulators. You guys mentioned earlier some of the eye-popping totals that in fines that were levied in 1 year. I think, Gurbir, you said $6.4 billion, and Ian, you said $4 billion. And for those of us who practiced before the SEC and CFTC, it's not a surprise that you guys are imposing higher totals, because we have noticed that the price for settlement has gone up on similar cases. So, we're all lawyers, so we use precedent. When we come in, we tell you what we think would be a fair settlement, and we point to things that have happened in the past. We do that in the criminal context. It's one of the factors under 18 U.S.C. 3553A, and we try to do it in the civil context. But Gurbir, you were very forthright here a couple years ago, and I think you've said this other places, that you don't feel bound by precedent. You don't feel bound by what the penalties have been in the past, because if the same kinds of misconduct keeps recurring, that kind of shows that deterrence is failing and that the penalties haven't been high enough. So at the risk of, again, asking you to tell us all how to do our jobs better, what do we do when we come in if we can't point to precedent and say, here, this case, we're not as bad as this company, or, we are as bad, but it didn't rise to the C-suite level, or how do we distinguish ourselves or not distinguish ourselves and try to figure out what to tell our clients a reasonable range of penalty is?
So just to be clear, I'm respectful of precedent, legal precedent, prior resolutions that the commission has had with other entities. And I think I shared this, maybe it was a couple of years ago here in San Francisco, but I think it might be worth sharing again. I was brand new to this role, and one of your colleagues, and maybe you'll get it out of me which one and who started this, came in for a Wells meeting. And I could imagine some associate at some big law firm spent upwards of like 40, 50, 60, maybe even more hours going through the commission website, finding every similar precedent for the violation that they were going to come and talk to us about, put together an incredible chart attached to their Wells submission, which was, over the limit to begin with, but then we had this huge chart at the end of it with every prior precedent, and then they came in and said, hey, Gurbir, look, what your folks are asking for in this settlement is completely unreasonable, and it's not tethered to these prior settlements. If you look at every prior violation of this type, the highest penalty has been X, and there's never been a penalty in this range. Every violation is $1 million or $1.5 million or whatever the case may be. And I said, listen, if I look at that, and your firm is part of a number of those prior resolutions, what it's showing to me is that those prior penalties are not having the deterrent effect that they should. That maybe we ought to think about different remedies and different penalties, and maybe we need to go a little bit higher, because in some cases, those penalties are less than a rounding error for your firm. And so we have to think about it in a different way, I think, as a result of that. And so, precedent is great, but what we're not going to do is, it's not the starting point and the ending point. So we're going to look at the prior resolutions. We're going to look at the statutory tiers. We're going to look at the benefit to the violator. We're going to look at prior judicial opinions, and we're going to work and figure out what a meaningful penalty number looks like in that particular case, one that's going to have the specific deterrent effect, the general deterrent effect, and going back to what we were talking about earlier, what the AG also mentioned, what's going to enhance trust? What's going to show people that these penalties are more than the cost of doing business, that there are real meaningful ways to have accountability in this particular matter? So that's what I meant by that. By all means, come in with those. but it can't be the starting point and the ending point. It's an important data point, but we have to take into account the recidivism, which we talked about earlier, the prior violations, what's going on in the space, and what's going to have a deterrent impact on the particular violator who's coming in to talk to us.
Ian, what about the CFTC? I think you guys extracted, millions and millions and millions and millions of dollars in penalties in reporting cases that if you would have told, someone in the derivatives bar 5 years ago, they wouldn't have believed you. What's behind that, and is there kind of a more general effort to make penalties larger in an effort to increase deterrence?
Yeah, I think it's important to just get a little granular on it because the cases you're talking about, I think I mentioned them in the beginning, swaps data reporting cases, which in our view had just been happening again and again and again, and sometimes by the same entities. And there I think, look, we don't want higher penalties just for the sake of higher penalties, right? It's when we see recidivism in our markets, and not only when it's by the same firm, but when there is a well-known failure that may be applying across the board, and other folks aren't taking that seriously, and they're not remediating or self-reporting. I think they're just generally, though, then kind of stepping back when we're outside of the recidivist context. I think precedent for us, which is prior orders often, sometimes court opinions, but much less frequently. I think it is, as Gubir said, a very useful starting point. I do find it useful when folks come in and walk through all the prior orders and the facts. I think that's helpful. I just don't think it is dispositive because we think things change over time. Things become more important to the public and to markets and need more emphasis. I think the other piece of that is penalties need to be high enough that firms don't just think they're the cost of doing business, right? And we've had, I think maybe some lawyers were too candid with us previously about not really worrying about this particular problem because they thought that the fine would be something that they could handle, and then worry about what happens next. And I think that is...
So that's something we should not say.
No. So if you ever want to get a regulator to have their backup, I wouldn't do that. But
Jason's writing that down.
But the other piece of it that I think is important, and we've gotten this feedback from compliance officers, is they have to have business conversations with their superiors, often non-lawyers, often folks who are just what is it going to cost? What would it versus what would that cost? To try to fix the problem, right? So some of it is trying to arm them in those conversations so that the business folks know that the consequences, if the facts support it, could be severe.
Got it. Okay, I want to leave time for questions from the audience, but I do want to touch on something that the Attorney General brought up, and that is AI, the promise and the peril of artificial intelligence.
Not Taylor Swift?
Well, that too. I'm expecting that to be the questions. Izzy, if the U.S. Attorney's Office for the U.S. Attorney for the Southern District of New York is the Sheriff of Wall Street, I dubbed thee the Sheriff of Silicon Valley. So talk to us about AI.
A couple things. Just the Attorney General's Advisory Committee and the White Collar Crime Subcommittee. It's an area that we're looking into, and recently we've launched the AI Working Group headed by Zach Cunha from Rhode Island. And it is something that we're focused on here. We're focused on various aspects of it. First, just in our restructure in terms of the corporate and securities fraud. It's a core area of our priorities are fake it till you make it schemes. We talked about Theranos a little bit earlier, and we've seen that in the AI space as well in terms of companies misrepresenting what their capabilities are, and that's a strong focus of ours in terms of investigating those. Also, the terms of just the use of the technology, generative technology, and various frauds, affinity frauds, are things that we're focused on. More it sort of turns, as people have said, the minor league player into the major league player and their ability to commit these frauds, and we're just seeing a true spike in that in all kinds of areas, whether it's a ransom fraud, a grandchild fraud, other areas of that nature. So it is something that we're focusing on with our new structure, particularly here in Silicon Valley, as you said, and the Cerebral Valley, as they say, which is specific to AI.
Marshall and Gurbir, both of your respective bosses have recently given major speeches on AI. What's new in AI from your perspective?
Well, I'd urge folks to take a look at the Deputy Attorney General's speech from a couple weeks ago in Oxford in England, where she went into in some detail how the department is thinking about and approaching AI, both in terms of the way that we at the department use AI and to avert abuses of AI, and also in the way that it poses risks from a criminal and national security perspective. So I won't reprise that, other than to say one element that might be of importance to this audience is she talked a little bit about how where AI increases the seriousness or danger associated with criminal offenses, that our prosecutors will be asking for increased sentences, akin to the way that sentences increase when a dangerous weapon like a gun is used, when a dangerous technology like AI is used to supercharge an offense. We'll be asking for more significant sentences. I think you'll see that also play out in the corporate space, and I think you'll hear some more about that from the Deputy Attorney General tomorrow as well, about how from both a sentencing perspective and from a compliance perspective, we at the department are thinking about AI and how this audience and your clients should be thinking about AI as well.
Okay. Gurbir, what was Chair Gensler's perspective?
Sure, same plug. I would recommend that you go read the chair's speech. Not only does it talk about AI, it talks about a lot of movies that he likes and that reference technology. And I think it starts with the movie Her, which I've never seen, but it's an interesting read. From my perspective, and the chair touched on this a lot in his speech as well, there are sort of 5 buckets of risk around AI that we see from the SEC. Number one is what the chair's referenced as AI washing. It's very similar in my mind to ESG or greenwashing. What we saw when ESG was important and front of mind for investors was we saw a lot of issuers talk about their ESG practices. We saw a lot of advisors offer ESG branded products, and those products didn't really live up to what the policies that they said that they would follow when they were making investment decisions. We see the same thing in the AI space. We see advisors saying that they're incorporating AI into making their investment recommendations to individuals. We see advisors talking about investments being made in a certain way in certain investment products that they're offering to the investing public, when in fact that's not true. So that's an area of focus for us in enforcement. It's a priority for our examinations division. And the same thing when it comes to issuers and their disclosures. Their disclosures around risk when it comes to AI, if they are dependent on AI for their business and for their future profitability. So AI washing is certainly top of mind. Number 2, from our perspective, would be the use of AI in fraud or market manipulation. We are keenly aware that the use of deepfakes on social media or the use of AI tools to pump up a stock or to put out false information into the market is an area of risk. And so that's a place where we're putting a lot of effort and attention. We have a lot of in-house expertise that we've developed around AI, and we're bringing that to bear to surveil the market to make sure that sort of conduct is not happening. The third bucket would be conflicts. So if an advisor is actually using AI in their business, is that technology putting their interests ahead of their client's interest or putting their client's interests first, as they should? They have fiduciary obligations to their clients. They have obligations under our regulations to their clients. And so what are they doing to guard against that AI technology favoring them over their clients. There's a potential for new rulemaking around this issue that the Commission is considering as well. But again, another area of focus for us. The fourth would be hallucinations and really just mistakes. We've heard a lot about AI tools hallucinating and sort of doing things on their own or making mistakes. If advisors or if others are relying on AI tools to make marketing materials or other things that they're going to share with investors, and there are mistakes in those offering documents or mistakes in those materials, how do we get the state of mind that we need for some of our violations in those cases? So it's a little bit of a challenge. It's something that we're looking at very closely. And I think the final area of risk that we see from the Commission's perspective, and the chair talked about this a lot, is the systemic risk flowing from AI. When you have less and less big players in this space and more people relying on a fewer number of aggregators or others who are putting these tools together, there's a possibility of herding, that a lot of people are making investment decisions based on the same data sets. And when you create these type of monocultures, there's always a systemic risk that if something goes wrong, how interconnected we are in our financial markets, it could have a ripple effect and it could cause a crisis. And the chair talks about that a lot more eloquently than I can in his speech, and I would direct you to read that. And so those are, broadly speaking, the areas of risk we're seeing around AI from an enforcement perspective at the SEC.
Ian, algorithmic trading has been prevalent in the derivatives markets for over a decade now. How does that impact the way you guys are looking at AI in the markets?
Yeah, I mean, it certainly impacts the way that we are thinking of approaching AI. And I'll just say, before I get right into that, we are very focused on AI as well. We have a task force that I stood up earlier this year on emerging technologies, including AI, and how to be prepared because it is certainly in our markets already. I think in some respects, AI cases for enforcement, we've already brought some in the bucket of what I think Gabir just called AI washing, where a trading firm represents to the public that they have an AI bot that can't lose or that will cover your losses, and we've brought a few of those cases already. They often involve where folks are targeting retail participants. But you could see that also playing out with more sophisticated firms, right? As investors want to know what AI capabilities a firm has, I think the disclosures that they put out there will be very, everyone would want to make sure that is entirely accurate. Your mention of algorithmic trading, Eitan, and I think it was under your leadership where there was almost a proposed rule. There was a proposed rule to regulate algorithmic trading. So quick thing on algorithmic trading, it's not exactly AI, but the human programs the algorithm, and the algorithm does what the human programs with AI. Just in short, as probably everyone here appreciates, once the program is created, it can go do kind of whatever it wants and learn from itself. And so for algorithmic trading, because it was a problem in our markets, we had a case, I also think it was under your watch, of a person who had designed an algorithm. Eitan's just looking for credit. So, but where the defendant set up an algorithm to spoof, right, a form of market manipulation, and we charged that person. We also charged the software developer, and the regulations at the time, they were never passed, but they were contemplated, would have required risk management procedures, supervision of algorithmic trading. I think one of the requirements was even that the source code be kept and any editing to the source code be preserved, so that we could look back, or anyone could look back and see who made what change when, so that there would always be the ability to see if a human should be accountable. And so I think that kind of rubric of making sure firms are adequately supervising AI in their trading decisions is something that will be important to us. We do not have a proposed rule on AI out there now, but what the CFTC did is put out a request for comment to our registrants on how they are using AI. And one of the questions in there was what kind of controls do you have in place to prevent any kind of AI trading program, from manipulating the market or committing any other kind of fraud?
We had other topics that we hope to cover, but I'm acutely conscious of the clock ticking down, and I want there to be an opportunity for audience questions or comments. So if anybody does have a question for any of the panelists, if you guys could just make your way to the microphone and
Hello. Hi, Max Fillion with GIR. I had a question about the kind of national security issues that AI presents. I know that Deputy Attorney General Monaco said that the DOJ was going to prioritize cases involving that. So I was wondering, what is the DOJ kind of on the lookout for? What threats does it pose when our adversaries have their hands on technology? Is it like military technology, deep fakes? Like, what kind of things are you trying to look for?
Sure. Well, I'm happy to take that one. Thanks for the question. Look, I think the Attorney General started to get into that earlier today when he was in his chat with former U.S. Attorney and former AAG Polite. And what he was talking about, I think, was a number of risks. I think the first one was exemplified by the case that we saw charged today, where an insider at one of our top technology companies in the United States was charged with stealing intellectual property associated with AI, and also with doing so while working for foreign companies in that space. So I think that presents already for itself the threat that we've seen in other disruptive technology spaces about technologies that could be used to assist our adversaries and against our country being stolen and then exfiltrated or exported out of the country to our adversaries. So that's a set of risks in and of itself. As a result of those risks, Deputy Attorney General Monaco stood up our Disruptive Technology Strike Force and has, as you probably saw from her prior speech, sort of identified AI as maybe the most disruptive or the ultimate disruptive technology. And so that's a real concern that we have. I think, as the AG mentioned also earlier, the threat that AI can be used as a tool for some of the cyber crimes that we're seeing attacking our companies, our government agencies, hospitals, schools, and causing incredible disruption to our economy and presenting national security issues. As you think about how AI can be used as a learning tool, whether it's in the phishing space that the AG mentioned, or whether even to take sort of a brute force password stealing effort. You can imagine how much more effective a brute force password stealing effort is, where in other words, where they try every password known to man until they find the right one, when you have AI technology to supercharge that effort. So in the cyberspace, I think it also presents a real area of concern. And then I do think that there's concern about the way that AI could be used in weapons programs in some of our nation-state adversaries. So it really presents a host of potential risks and problems. And so all the more reason why we need to focus on our attention from a prosecutorial perspective, from an enforcement perspective, and we need to partner with industry to do so, as we have in the disruptive technology space, to try to work together to protect our country and our economy from some of those risks.
We are unfortunately out of time, but I want to thank the panelists for coming here, making yourselves available. I know you're all really busy and appreciate it.